Free, right behind you.
Hey, strange.
Vice Mayor Strange, you'll address her properly.
You can kiss my foot.
Mr. Rickard, you're out of order.
FBI, we are asking you to investigate this council. Please look into this council, how they award contracts, the bid process, how they use their positions to benefit their friends and themselves, how they use their positions to attack residents and critics and neighbors and business competition. FBI, will you please look into this?
And I welcome the FBI here. If you notice, Mr. Thompson with his plea for the FBI and his watchdog group, this city runs the cleanest in this whole county. I guarantee
He
that.
was served a federal subpoena this morning.
Did receive a subpoena this morning, and we're going to cooperate 100% with the subpoena. And
most of you who were involved up here, you gaslighted me. You tried to say I was crazy. And now we know that that's not true. And there's a lot of other issues I've been asking about as well.
So about 10 days ago, well, I can tell you exactly when. Just about on the 6th of January, there was a court filing in the Lynn Haven case involving developer James Finch and former Mayor Margo Anderson. And it really, I don't think WMBB touched it, but they did touch one of these. All right. So do you remember I told you that at the evidentiary hearing on December 13, federal judge, Chief Judge Mark Walker looked at all of the evidence that was provided in the evidentiary hearing as the trial continues to be set for February 28. So it looks like we're about 6 weeks away from the trial. And it looks like it's really going to happen. In 6 weeks. It kept getting pushed back, but at this point, I don't see it being pushed back again. And during this evidentiary hearing, the defendants were telling the court that we haven't got, the government, the prosecutors, still have not given us all of the exculpatory evidence. And we want to show that to you, Judge. Also, it involved a motion to compel the government, the prosecutors, to provide the evidence that could show that they're not guilty and maybe even would show that somebody else or others are. And so that's what it was about. They're not televised. They're not recorded. So if you get any information from a federal proceeding, it's just through notes or transcripts. And the transcripts have not been released by the court. And that was so disappointing too, by the way. Now, again, there's a lot of confusion about if it's sealed or if it's not sealed. I can go down there. Remember, I sat through all of it and took notes, as did the Beacon of Bay County. And I was going to say, as did WMBB, but they didn't take notes. They were there. Brady Cowan was there, but wouldn't you love to see his notepad? All 2 pages. Now, so if you're talking about a federal proceeding, you have to go based on that. Now, even though the court hasn't released the transcripts to the public, I can still go down there and look at them. That's even better than, say, Lynn Haven. Right? If you want to go down there and look at, I don't know, the police code of ethics, it's just, 100 and how much was it? It's about $100 probably. But if you want to go down and look at the transcripts for the federal case in Lynn Haven, you can go look at them. You can take notes. So anybody who tells you we don't know exactly what was said in there, we don't have the evidence of what was, yeah, you do. They're lying to you. You can go look at it if you didn't attend it. And even if you did attend it. All right. So that's what that was all about. And at the end of that, the result was that Judge Walker was surprised a few times about what he saw. Remember, I told you who he asked the prosecutors. He said he didn't know that the FBI was putting corruption in boxes because they say there's so much corruption in Bay County. But the only one they can really nail is the former mayor of Lynn Haven, Margo Anderson. Hey, that's the only one we can really nail, Your Honor. But they really aren't nailing her. 62 of the 64 counts have been dropped. They themselves threw 25 of them out not too long ago. Judge Walker was incredulous. And so was anybody else who's interested in what's going on. So he said, I'll tell you what, to the defense on December 13th. Give me a list of who you think are the bad actors and the bad acts. And they did. It was a post-hearing supplement, all right, that was directed by Judge Walker. It wasn't a motion. And in it, they listed, I think they listed 6 people, the defendants did. And number 1 was the main prosecutor, Stephen Coons. Number 2 was the FBI agent, Special Agent Larry Borghini. Now, both of them have retired. Borghini retired a year ago, and Coons retired right after Judge Walker said, send me a bad actors list. They also listed, and this is something the WMBB won't say his name because they've got a family affair going. And it's Major Jimmy Stanford at the sheriff's office who heads up their public trust unit. Who else would you pick? He's the top detective over there. Okay. And I'll show you the documents here. And then they also listed Lynn Haven Police Chief Ricky Ramey, Lynn Haven City Manager Vicki Gaynor, and former Lynn Haven City Manager Michael White, who has pled guilty already. So those are the bad actors. They filed it and they explained what the defense said that they did that was vindictive, that was reckless, and so on and so forth. Then about, 3 weeks ago or so, maybe 2 weeks ago, the prosecutors responded to that. All right. And they said, because we didn't have much time, we didn't have enough time to really do our due diligence here, Your Honor, because you didn't give us enough time, Judge. We're just going to be snarky. And their response was nasty and petty. For example, they've dropped the whole charge about the mayor had her home cleaned up, because in the evidentiary hearing, they showed the land survey, and the judge said this, right there. The judge said the land survey shows it's not Anderson's property. Do you know that WMBB still hasn't told you that? It's in the transcripts. You know, if Brady Calhoun missed it, it's in the transcripts. That's quite something. But in the response to the bad actors list, the prosecutors kept talking about that. They've dropped the charge. The judge, everybody said, yeah, geez, not on the but they keep talking about it. It's unbelievable. So then on January 6th, James Finch, his lawyer, gave a final rebuttal to that. And that's what I'm going to show you. It is hot. So if you think somebody ought to see it, now's the time to tag them or share it, because it's never been discussed before. It was filed in court. It's a public document, but I guess it's too hot for WMBB to share with you, but I'm going to do it in just a minute. It's a hot time in Florida, and my friend Ryan could make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at PCAirRepair.com. Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3 3777. All right, here we go. This is the court filing that hasn't been discussed yet. It is the reply in support of Defendant Finch's post-hearing supplement identifying specific relief sought. In other words, the defense is saying that the investigation and the prosecution has been vindictive and reckless, and that's the reason 62 out of 64 counts have been tossed. And, it's not crazy to think that. 97% of the counts against Margot Anderson have been tossed. And so there's 2 left. And now the defendants, because they're being charged together, are saying, we think the whole thing ought to be dismissed. The rest of the indictment, the latest indictment, the 5th rewrite. And the judge said, what if I don't get to that point? What if there are lesser sanctions I need to do? Show me some options. And he said, look, this is not a wish list. But he is considering right now, and he's got all the documents to do it, he could issue a ruling on this any day. So here it is. I'm going to read through it. It's 11 pages, I believe. Let's see how many pages. 11. Really 10, because the last page is just a signature. Okay, so despite having ample time, this is the defense attorney, to address the evidence of its misconduct thoroughly and carefully, the government instead attempts to shift blame as it has done in the past. And then there's a footnote. I'm not going to read through all the footnotes, but in this one, it talks about the government has repeatedly shifted blame for its discovery misconduct, claiming it did not provide grand jury excerpt containing the solicitation of false testimony to the defense until months later because, quote, the defense counsel did not specifically ask for the transcript, end quote. And then it talks about suppressing an unrecorded verbal agreement permitting Christopher Forehand, the city contracted engineer, to avoid questions regarding his criminal conduct, and then blaming the suppression of the information on an agreement between Borghini and Forehand's counsel. Remember, Borghini was the FBI agent. And, this is the defense saying that there's criminal conduct. The prosecutors have not said so. The investigators have not said so. But evidently, he's got immunity. For what? It's a good question. Immunity for what? All right. So this time the government claims it could not respond in full given the time afforded. In other words, Judge, you didn't give us enough time. A careful reading of the government's, and they also point out the defense that the government did not seek and the defense never opposed a request for additional time. So the defense is saying, look, if you needed more time, you should have asked. And they never did. Instead, they turned in something virtually without substance, and it was very lacking. You can see it yourself. In the response, the government concedes misconduct, and the government wrongfully suggests there is no legal or factual basis for sanctions. Defendant Finch respectfully urges that the court strongly consider dismissing the last bite at the apple with prejudice. Alternatively, as requested by the court, we have presented the court with alternative sanctions to address the government's repeat history of violating court orders, discovery abuse, due process violations, and grand jury misconduct. Uncontested bad actors and bad acts. The government's papers do not meaningfully address the bad actors and the bad acts. They do virtually nothing to rebut the arguments and evidence raised in the court-ordered post-hearing supplement. Specifically, the government completely failed to address the evidence detailing a history of vindictiveness and outrageous misconduct, including, these are the specifics, the government's repeat history of returning legally flawed indictments in the case. Legally flawed indictments. Remember, this is the 5th one. They had to rewrite it 4 times. The FBI agent and the prosecutor, their repeated misstatements of fact regarding the transfer of the motorhome between Finch and Lee Anderson. Margot Anderson's husband. Number 3, the prosecutor Coons' prejudicial misconduct before multiple grand juries. Number 4, the government's misrepresentations and conduct surrounding Finch's request to voluntarily surrender. The government's attempt to publicly arrest and embarrass Finch in Lynn Haven following the superseding indictment and the FBI agent's unhinged call to Finch. Evidently, he made a phone call when he went to arrest Finch, and Finch was actually at the attorney's office waiting to turn himself in. And evidently, the FBI agent was furious that there was, not that big moment on TV. Number 5, the illegal use of Sachs Media Group to publicize the government's actions, attempting to poison the public with inaccurate, prejudicial allegations. And that's interesting because I hear all the time, not all the time, but I hear people say, Bernie, when you do this kind of stuff, one time I turned in I tried to submit an article. This is during the Sheriff Nick Finch situation back in 2014. I wrote an article outlining what I thought was going to happen in the case, and it did. And it was to the Tallahassee Democrat. And the editor responded that we don't try cases in newspapers. We let it happen in court, and then we'll take people's opinions. To which I said, well, you used to, because I showed them the article they published when I wrote in 2008 about the boot camp case in Bay County, and they published that one. Real newspapers do publish opinions that are supported by facts. All right, let's see here. But what's interesting, though, is they have been very public. I mean, they had big press conferences. And they said that a mayor had committed 64 crimes. And now we know that that's not even close to being true. That's what that's about. Number 6, the use of an off-the-books immunized informant to invade the defense camp in violation of the 6th Amendment. Number 7, repeat violations of the court's discovery orders, including but not limited to late productions, improper redactions, and withholding of Brady material. That's discovery material. Exculpatory material. Until the defense discovered the government's misconduct. A co-case officer's, Major Jimmy Stanford's, destruction of written witness notes, despite the government's representation to the defense that all officers and agents were instructed to preserve them. So in other words, the prosecutors told the defense that everyone who was all the public trust investigators, when they interview witnesses and suspects and all that stuff, people of interest, they write notes, right? That's what you do. And the prosecutor said, no, everybody's going to keep, of course, we're going to keep our notes. But when the judge said you got to turn them over, evidently the defense is saying that Major Stanford's notes were destroyed. It didn't exist. So they put that in there. The misconduct remains uncontested by the government and alone warrants severe sanctions. Unfortunately, this bad conduct is in addition to what has previously been cataloged and caused the court to conclude that the government's misconduct was less than laudable. That was in the middle of last year, these quotes. This is what Judge Walker said in a ruling, that the prosecutors and investigators were reckless, careless, and unprofessional and haphazard. After the government's misconduct was brought to light, the government regularly blamed others, including the defense, and denied responsibility. This is the defense answer, the latest filing. 2, uncontested exculpatory testimony. The government fails to address or rebut witness testimony. And this is incredible. When you've got witnesses, including your own, who say they didn't do it, and you press on anyway with the last crumbs of this disaster of a distraction, and you just keep pushing forward anyway. I mean, even though you've got all these witnesses, including their own, saying it didn't happen. The exculpatory information directly contradicts the indictments, the grand jury testimony, what they told the grand juries, plural, and the agent's reports. For example, former Commissioner Antonius Barnes maintains the fact that the loans he received from Finch were neither bribes nor connected in any way to his duties as a commissioner. He testified to that in court a few weeks ago. George Roberts, the big contractor, testified that he was responsible for setting up Finch's pit for debris disposal, not Finch and Anderson, as the prior indictments would suggest. I was there for his testimony, and it was very powerful. Troy Seifert testified that Finch was not in a state of mind after his stroke and rehab to be making decisions and telling people what to do, where to go, and how to do it. Remember, in all of basically from October 4th to October 30th, the hurricane was on October 10th. Finch was in the hospital in Jacksonville. He was in a coma for a while. He had a brain bleed. I mean, but by the way, the government told the grand jury that he was just out of pocket. They never said that he was, they never told the grand jury. That is incredible. Bad faith? Just out of pocket is what they said. You're going to see something here in a minute. Alan Bird testified. Another contractor testified that he observed Derwin White, not Anderson, directing debris disposal, and he was headed off at the pass by Mickey White and Michael White when he was trying to offer an alternative disposal location. That's true. I've seen the evidence. There's a current lawsuit that Alan Bird has going. I've seen the emails, and it's absolutely true. Beyond uncontradicted testimony, records show that Finch was in the hospital up until October 30th, 2018, despite the prior indictments indicating that he was directing debris disposal and holding meetings on his house on October 30th and October 31st. He did not return to Lynn Haven. He didn't get out of the hospital until October 30th. There's his rehab document right there. Just out of pocket, that kind of thing. All right, multiple individuals testified in court and to the government, to the prosecutors and investigators, that upon returning to Lynn Haven, Finch was not in any state of mind to convene a meeting in his home to discuss debris disposal. The government is still standing on, and the entire thing rests on, whether or not he had a meeting at his home on October 31st. That's their top argument now. I watched them tell the judge that. Is that something? So when people say, Bernie, why are you defending, and why are you now a Finch cheerleader and a Margot Anderson cheerleader? That's what I've been asked. That's the dumbest question I've ever heard in my life. I've been telling you what I am seeing, and it is playing out that way, just like it did in the boot camp case, and just like it did in the Liberty County Sheriff case in 2014. There are a lot of people who cannot believe that somebody will tell the truth because it's the right thing to do. And the painful thing to do sometimes. But you deserve it. If we're going to be any kind of a democracy, a republic. I know that there's going to be equal application of the law. People have to know what's happening. And this is what's happening. All right. So they say he had this meeting in his home when he was not home, or he just returned home from, I don't know, being indisposed, out of pocket. A stroke is what they mean, a coma. I'm angry about it because they know who really did it. They've told a judge who really did it in order to get a search warrant on GAC contractors a year and a half ago. They know who really did these things. They've got it. But they're doing this. Why would they do that? All right. So making impossible the allegations in the prior indictments charging Finch with directing a meeting in his home on or about October 31st. Of course, multiple witnesses likewise stated that these allegations of corruptions were not true. And then they list the people who said that: George Roberts, Jim Slonina, Mike Swearington, Troy Seifert, Chris Forehand, Ralph Natal, Chris Forehand, and Chris Forehand again, according to the FBI notes that are known as 302s. And that's what those numbers are there. It appears. So why do they believe that there was that Finch, when he just got home, the moment he got home, he's calling meetings, snapping his fingers, telling everybody, meet at my house. Everybody met at his house, and he directed everybody where to put it. Why did they believe that? Or why do they even, what grounds do they have at all? They don't believe it. Nobody believes that. I can hear it in their voices when they tell the judge that. They know it didn't happen. But this is what they're standing on, right? So where did that even come from? Well, look at here. It appears that the source of this false accusation stems from Michael White's pre-plea agreement. What is even a pre-plea agreement? Interview that was conducted by the FBI agent on December 11, 2019, where Michael White claimed all these people. Michael White told the FBI that all these people were convened at Finch's house on October 30th or 31st. You had Finch, Margot Anderson, Chris Forehand, Jim Slonina, who's a co-owner of Panhandle Engineering, Matt Marshall, Troy Seifert, George Roberts, and Derwin White. They were all in attendance, said Michael White. So he told the FBI in 2019. And it says, see the notes, right? The FBI notes. It also appears that just in October of last year, the day before the government returned a third superseding indictment, which is a fourth iteration, that Michael White conveniently recanted and modified his prior testimony, narrowing the alleged attendees to only Finch, Anderson, Derwin White, who's dead, passed away about a year and a half ago. And so now the government says that the defendants are conveniently blaming everything on him, but it's actually the prosecutors who are saying that he was there based on Michael White's altered story from a few months ago. Okay. And himself, he says he was there. Wow. What I notice is this too, by the way. What I notice is that there's a lot of lying to the FBI, or the FBI is writing things that they never said. Probably one or the other. But they don't care when the witnesses they're using change their story or outright lie. And I got a story for that, about that coming up, involving Vicki Gaynor. It is further uncontested that all actions taken by the Lynn Haven Commission were in public and on video, demonstrating that the process was devoid of impropriety. For example, Commissioner Tinder made it clear that it was she, not Margot Anderson, who thought the Finch-inspired design-build project was a cost-saving way to rebuild much of Lynn Haven. The design-build project, from what I've seen, basically cuts out the $1 million consultants. Good idea. But you had people telling, yet a person told the FBI that if they had cut out the consultant and done Finch's design build idea that Judy Tinder, not Margot Anderson, proposed, then they wouldn't get any refunds or payouts from FEMA. That's what one person told the FBI. Turned out it wasn't true. Look, the FBI agent and the prosecutor, neither of whom are still employed by the Department of Justice, orchestrated this false narrative. The list of exculpatory information goes on and on and on, all unrebutted and all demonstrating that the prior indictments were obtained totally devoid of any sense of truth, honesty, or accuracy. In short, the unrebutted evidence directly contradicts the information presented by the government through FBI agent Borghini and prosecutor Coons to multiple grand juries. The presentations in large measure were false, misleading, and vindictive. The allegations were made without regard for the truth. And as the stakes became higher, the government proceeded with equal reckless abandon. A duly elected mayor was removed from office based on a host of false and reckless misrepresentations. An upstanding businessman's reputation was ruined because, based on the government's cascade of lies and misrepresentations, leaving the businessman to be blackballed by the current city manager, Vicky Gaynor, all based on lies presented to multiple grand juries by Borghini and Coons. The misconduct warrants the most severe actions, dismissal. So Judge Walker he has all this, and he's had all this for a while, and he is going to make a ruling on whether or not this is true, and whether or not it warrants sanctions. And we're just sort of waiting on whether or not he sees anything here that warrants sanctions or dismissal. He might come back and say that there's nothing. There's no telling. But everybody's sitting on pins and needles, and this was the last filing to the court. So this part, the blackballed, let me explain to you what that's about. So the defense says that Finch was blackballed by the current city manager, Vicky Gaynor. Could that be true? What did she say on the witness stand? Well, I'll tell you because I was there right after this.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
Have you received a speeding ticket for which you want no points placed onto your driving record? I'm El Saulene, 850-215-0628. Let me help you.
So what is that about? Because it was interesting, because Judge Walker talked about this. In fact, that was his word. He said blackballed. It turns out that current city manager Vicky Gaynor admitted to telling Chris Forehand, the city contracted engineer with Panhandle Engineering, that something to the effect that it would be in his best interest, or it would be a good idea not to do business with Phoenix Construction privately. The implication, of course, is that if you do business with Phoenix Construction, you may not be the city contracted engineer anymore. So she leveraged her position as the city manager to try to hurt Phoenix Construction. And the theory is, and it's probably true, I don't know for sure, but this is, I think, was the motive here, is I think Vicky Gaynor believed that Finch did not think she was a very good city manager, and she had the feeling that he was trying to encourage people to vote her out. And I could imagine that that's true. But because of that, she leveraged her position and blackballed him out of business to which he was entitled. That's how the judge worded it. At least when he reiterated or stated again what the defense was saying and what she was saying on the stand. All right, so number 3, the government admits to multiple instances of false testimony before a grand jury. Rather than addressing the overwhelming evidence of misconduct, the government offers additional points, attempting to seek reconsideration of the court's prior findings, middle of last year, that the government and its agents acted recklessly, carelessly, and haphazardly. At the same time, the government concedes that multiple mistakes regarding the truth before multiple grand juries were made. The government again attempts to deflect from its misconduct by characterizing false testimony as inadvertent or immaterial. The arguments are disingenuous and should be summarily rejected. Sanctions should be imposed, say the defense attorneys. The defendants are substantially prejudiced by the government's pattern and practice of shooting first and asking questions later. When an individual's liberty, livelihood, and reputation are in jeopardy, precision matters. The record was already replete with the government's careless disregard for truth. The government's current response is no different. For example, the defense has repeatedly asserted that the government created a false and misleading narrative by lumping Margot and Lee Anderson together regarding the motorhome transaction and supporting documents. That's been a series of incredible allegations that they've walked back time and time again. And there's documents to that. That's going to be interesting if it ends up going to trial on February 28th. The court even noted that the FBI agent's statements and the prosecutor's questions were at minimum misstatements of fact. That's what the judge said. This, however, has not thwarted the government from continuing to make objectively false statements about defendant Anderson. It's shocking what they say, what they continue to say, even after they drop the charges. In fact, the government falsely represents to the court, they're telling the judge now that Mayor Anderson's yard was really 3 properties which were combined into one. Remember, I mean, that's what they're telling the judge now, even after the judge said this. Can you read my notes? The land survey shows it's not Anderson's property. That was after a lengthy examination of the property lines in court, and they're still saying it. This reckless disregard for facts is belied by public records, sworn testimony, and uncontested defense exhibits. The government also suggests that there is no basis for the court's prior determination. In other words, what Judge Walker already said, that the government presented testimony about FEMA reimbursements that it knew or should have known were false because it was merely relying on a witness's statement. In other words, the government argues that it should not be held responsible for failing to verify or corroborate a witness statement with readily available public information. In other words, the FBI agent was told something by one person that the city could not be reimbursed FEMA funds if they went with the design build that cut out the $1 million consultant. All right. One witness said that, and they acted like it was true. They didn't look into it. They didn't ask anybody else. They just went with it as though it were true. And they did this over and over and over again. It's publicly available, permits the use of design build contract. Yeah, it absolutely does reimburse for design build contracts. With all due respect, say the defense, easily accessible public information that directly contradicts the government's witnesses and theories of the case falls squarely within the realm of information the government should have known before soliciting false testimony before a grand jury. Lastly, the government also concedes that it failed to fully investigate the facts before soliciting inaccurate testimony from the FBI agent concerning the post-hurricane work performed at other city employees' homes. Yeah, including, and they all say this, by the way, including a member of the city commission. But remember, everybody else, for some reason, has some sort of protection. As long as they say that Margot did it, that Margot and Finch did it, they get protection. It is so brazen and blatantly a dereliction of duty. Nobody would investigate like this. If you were trying to figure out who stole your barbecue grill out of your backyard, you would ask more questions to find the answer. Just one question. And that's what we're going with. Doesn't make any sense. It's not helping us find the barbecue grill. But maybe the point is they don't really want to find the barbecue grill. That's terrifying. All right. Incredibly, it was not until after the court concluded that the government readily admitted that the grand jury heard false testimony that the government attempted to get to the bottom of it. So the prosecutors got caught, and then they said, we'll get to the bottom of what happened here, right? So that's like basically asking the guy who stole the barbecue grill, can you get to the bottom of what really happened? Or it would be, maybe it'd be kind of like asking the Fakakta lawyer, who's also the chief counsel oh boy, I see that I was on mute. I don't know how long I was on mute, but shoot. Anyway, I'm just going to keep going here. Basically, I was saying that's not how investigations work, which is exactly what Judge Walker said. When you don't ask more questions, obviously there are more questions than you don't ask them. You just go with the one witness that clearly is wrong. All right, so the government misstates the law regarding the court's discretion to fashion sanctions for the government's misconduct. Finally, it says the government claims there is no legal basis for Finch's requested sanctions. This argument is frivolous. The United States District Court judges are granted leeway to fashion remedies for violating its orders, as well as constitutional rules of fair play. Indeed, consistent with the Constitution, fashioning appropriate remedies is the very nature and discretion of the law itself. And then it quotes case law. So I'm going to skip down, okay? And that's all quoting case law. It is simply frivolous to suggest a federal district court judge does not have the discretion to impose sanctions for misconduct. Conclusion: the court should reject the government's empty response and fashion meaningful sanctions for the government's repeat misconduct in this case. So now you know the latest of what Judge Walker is looking at as he is ready to issue sanctions or not. Whether the sanctions will be, as he called it, the nuclear choice, which is to dismiss the remaining indictment altogether, or, and it seems to me he's leaning toward issuing lesser sanctions and more precision-based sanctions. It's kind of like that old who played that old game Operation, you got to be very precise when you reach in the air or it'll buzz. You remember you had the little tweezers and you'd reach in to the patient, and if you touch the sides it would buzz and the patient would die, or at least it would buzz and you messed up. So maybe he wants to be more precise in the sanctions and not just throw the whole baby out with the bathwater type thing. I anticipate lesser sanctions, but I've been wrong the whole time about this in terms of guessing what's gonna happen, because I thought the judge would throw it out back in the middle of last year, early last year, but I didn't know how it worked. Right? I didn't know that by law he has to issue lesser sanctions first. But that's what he's looking at doing, and it could happen at any time. And considering the trial is set for like 6 weeks from now, I wouldn't be surprised if his ruling comes out this week. Probably not much later, maybe next week. But when it does, you can rest assured I'll tell you about it. All right, with that, I want to thank also the Unknown Patriot. Thank you for your support. And I want to thank you for being here. And I hope that if you found this valuable, that you'll share it, tag your friends, help get the word out, because it's not getting out. And when the word doesn't get out, let's put it this way. I say this a lot, so forgive me. To the extent that there is public corruption is the extent to which there's no reporting of it. When government is not reported on, government will do whatever the hell it wants to whomever they want to do it to. And that's where we find ourselves right now. All right. Thanks for being with me, and I'll see you soon.